We're back on the video record at 1:15 p.m.
Mr. Epstein, as it relates to the charges you pled guilty to, are you saying today that those females that you interacted with sexually were prostitutes prior to meeting you?
I'm saying I pled guilty to the solicitation of prostitution.
Right, and you would certainly agree that that would require yourself and one other individual for that act of prostitution, correct?
Form. Also calls for a legal conclusion.
I pled guilty to solicitation of prostitution.
And are you saying that those females that were the victims, at least listed as victims by the state, were prostitutes prior to meeting you?
Form. Vague. Irrelevant.
I pled guilty to solicitation of prostitution.
Okay. Do you have any remorse for your actions against these victims that led to your plea of guilty?
Form. Argumentative.
I pled guilty to solicitation of prostitution. Not underage prostitution, simply prostitution.
Are you saying now that the subjects of that, which we're calling victims, were not underage when you engaged in sex with them?
Form. Argumentative. Speculation. And assumes facts not in evidence, as well as mischaracterizes the witness's testimony.
I pled guilty to solicitation of prostitution. Not underage prostitution, solicitation of prostitution.
I was of the impression that you pled guilty to a second-degree felony, that being procuring a minor for the purposes of prostitution.
That's correct.
Okay, so a minor is somebody under the age of 18, and I'm asking for the guilty plea related to that count. Are you at all remorseful for your interactions with that minor?
Same objections.
What minor?
The charge is procuring a minor. You tell me, who was that minor?
I don't know.
You were never told during your during the state attorney's prosecution of you who this person was?
No.
Why did you plead guilty to a felony charge that resulted in you going to jail without even knowing who the victim was?
Form. That question calls for attorney-client information, and therefore I'm going to instruct him.
Well, if it has something to do with any conversations with your attorney, I don't want to know. I'm just going off of the plea colloquy between you and the judge, where you understood the charges and you've been advised and apprised of the charges, and you still willfully pled guilty to the charges. So I'm taking now that you're saying you don't even know what those charges were about.
What was the question? I don't know the question on the table now.
Who is the minor?
I don't know.
And you were never told the name or initials of that minor victim by the state attorney's office or the prosecutor?
Not that I recall.
Well, just so that the jury understands, this method of paying underage minor females to bring you other underage minor females for sex is something that you do in New York, in New Mexico, in Florida, and everywhere. It's not just West Palm Beach. Isn't that right?
Again, form. It's compound. Again, it assumes facts not in evidence. It's argumentative. It's harassing. And moreover, we've already been down this road before in separate related questions that have already been asked and answered.
I'd like to respond to each one of your questions. However, today my attorneys advised me I cannot, and they advised me I must assert my Sixth Amendment right, my Fifth Amendment right, my 14th Amendment right under the U.S. Constitution. Therefore, that's what I'm going to do.
Where is the calendar or schedule of your underage sex appointments?
Form. Speculation.
Again?
I'm sorry?
Sorry, you said what?
Witness said again.
Where is the calendar or schedule that's kept for you of your underage sex appointments? Your appointments for sex with underage females?
Same objection.
And if there's not one, you can tell me there's not one. It's fine.
I'd like to answer each one of your questions today. However, I've been advised by the patient, therefore,
are you still in possession of the computers that were taken from your house prior to the execution of the search warrant?
again, am I still?
Are you still in possession of the computers that were removed from your house just prior to the execution of the search warrant?
I intend to respond to all relevant questions regarding this lawsuit. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions that may be relevant to this lawsuit, no matter how much I'd like to. So I must accept this advice or risk losing my Sixth Amendment right to effective representation. Therefore, I must assert my rights under the 5th, 6th, and 14th Amendment to the U.S. Constitution.
Who was it that removed those computers from your house prior to the execution of the search warrant?
Predicate.
I intend to respond to all relevant questions regarding this lawsuit.
It's my understanding that this computer system contained the complete list of names of underage minor females with whom you engaged in sexual activity. Is that correct?
You're asking me for is your understanding?
No.
You're asking for me to tell you what your understanding is?
Did the computers that were removed from your home just prior to the execution of the search warrant contain the complete list of underage minor females with whom you engaged in sexual activity?
Form.
Though I'd like to answer that question like all your other U.S. Constitution, I'd point out that involved in money laundering in order to fleece local investors. All your questions today, my attorneys have counseled me I must assert
as an organized criminal enterprise designed to sexually exploit minors.
Objection. Argumentative. Speculation. Calls for a legal conclusion and continues to assume facts, not an evidence.
Though I'd like to answer that question, Mr. Edwards, like most of your other questions here today, and hopefully we'll get to do so. Constitution.
Part of that organization,
and I must accept their advice or risk losing effective representation.
And as part of that organization, you developed code terms such as work or massage as opposed to engage in sex with minors. Is that true?
Form. Argumentative. Speculation. Harassing. Assumes facts, not an evidence.
You developed code terms such as you would ask these girls if they would like to give you a massage or work for you, rather than asking them to do what was going to be done, which is engage in sexual activity with you. Is that true?
Same objection. Objections.
Are you asking if I develop code words? Is that the question?
Code words.
I'd like to respond to that question. Unfortunately, today my attorneys have told me I have to respond by invoking my Sixth Amendment, 14th Amendment, and Fifth Amendment rights under the U.S. Constitution, or risk losing my amendment right to effective representation. Accordingly, I assert my constitutional rights as guaranteed by those amendments.
Well, what did it mean within your organization when someone, some underage minor female, was coming over to work for you?
What did it mean?
Right, what did it mean? What did it mean to you was going to happen when an underage minor female would either call to work or would tell you this person is coming to work for you at a specific time?
Objection. Vague, speculative, and assumes facts not evidence.
I'd like to answer that question, as most of your other questions today. However, today my attorneys have counseled me that I must invoke my Sixth Amendment, 14th Amendment, and Fifth Amendment right, or risk, and if I don't, I risk losing them as my attorneys, so therefore I must assert those rights.
You're laughing as if my questions are ludicrous right now, but you're aware that there were trash pulls from your home where there were message pads, messages taken by various employees of yours where these terms, massage, work, were used in conjunction with underage minor females coming over to your house, aren't you?
Same objections form as well, move to strike. And also assumes facts not in evidence. It lacks predicate.
You're aware of the trash pull and the message pads, correct?
Same objections. Do you have any documents with you here today that you speak of?
No, but at this point in time in the trial, there'll already be in evidence, so.
I'm aware of the trash pull. What's a trash pull? I'm sorry.
Are you aware of, well, I'll ask it to you this way. When would take a phone message for you, what would she write it down on?
Form.
I don't, the question makes no sense to me, sorry.
If another employee of yours were to answer the telephone, be it your housekeeper, house manager, would answer the phone, take a message for you, and write it down so that you could read it later, what would that message be written on?
Most likely paper.
Okay, and is that paper typically in the form of a message pad that has a carbon copy sheet to the back?
No.
Okay, you're unfamiliar with the documents that I'm talking about, that being a message pad that informs you as to who called, the time they called, and the purpose for calling.
And for purposes of the question, we're specifically talking about a message pad, nothing related to what you're defining as a trash pull, just what someone takes as a message.
Do I know what a message pad is?
No. Do you, in your home, do you typically have your housekeeper, house manager, somebody else, when they take a message for you, write on a specific pad that informs you as to who's calling, the time they're calling, and the purpose for them calling, and there's a carbon copy sheet evidencing that message?
Objection asked and answered.
Do you know what I'm talking about? I mean, it seems like
I know what a message pad is.
Do you know what the message? Do you use them commonly in your home, or did you back prior to your arrest?
I'd like to answer that question, but today my attorneys have advised me I have to assert my Fifth Amendment, Sixth Amendment, and 14th Amendment rights under the U.S. Constitution. So therefore, I'm going to do that, or I risk losing their representation.
Is my question to you confusing? I mean, do you know what I'm talking about?
Form. Not specifically, no.
Okay. The information.
Is there
that
something you have to show me so I know what you're talking about?
I don't have it to show you today, but if the information and evidence that I have learned through this process is accurate and correct, it would seem a foregone conclusion that you and I would be on the same page, at least about this document. So,
okay.
If we're going to get to a point where you're going to tell me, hey, this document doesn't exist, or I don't know what you're talking about at all, okay, that's fine, but that's something that we can. So here's my question. When a housekeeper or house manager would take a message for you from any caller, is there a specific message pad that has a carbon copy located near your telephones for them to write down the name of the caller, the purpose for the call, and the time called? Form. Is that something you're familiar with?
I'd like to respond to that question. Today my attorneys have counseled me that I must assert my Sixth Amendment, Fifth Amendment and 14th Amendment right under the U.S. Constitution.
When Kellen or a housekeeper or a house manager, whoever happened to be employed at the time, would take messages, what form would you normally or typically receive them in?
Same objections.
I don't understand the question.
When a caller would call the home, house manager or housekeeper or I don't know what you call her, assistant, would answer the phone and take a message for you so that you would know who called, what would they typically write down the message on so that you would have?
Objection. In an objective form, it lacks predicate. And your question,
Really?
it lacks predicate. Yeah.
Piece of paper?
This is going to play well. Normally they would write it down on a piece of paper
Yes, sir.
and give it to
Yes.
you.
I didn't say that.
Okay. When someone calls the house and you're not the person who answers the phone, let me strike that. Have you ever been given a message that is ripped out of a message pad that has a carbon copy to it?
Oh, I see. Okay. Well, I would like to answer that question, but today my attorneys would advise questions.
Between the years 2002 and
My representation here today.
Between the years 2002 and 2005, who was your house manager? And if there's more than one, tell us that.
The question's unclear, I'm sorry.
Okay, let me start with, between 2002 and 2005, did you employ a house manager
Form.
Where?
at your Palm Beach home?
I intend to respond to all relevant questions here today. Fifth Amendment privileges.
Do you know
I intend to respond to all relevant questions. Because I'm going to have to assert my right. Is that a question?
Not yet. When is the first time that you met her?
Therefore, I'm going to have to assert my rights under this.
There's a female
Excuse me.
that was born in July of 1988.
Is that a question?
Not yet. When is the first time that you met her?
Objection, speculation.
That assumes that he did meet her? Is that what you're saying?
Your question assumes
He met her.
exactly what you just said, and which has not been established on the record yet, pursuant to the appropriate flow rules of civil procedure and the evidence code. It lacks predicate.
Good.
That being said, I'd like to answer that question, but today, Fifth Amendment, right? Appreciate it.
Isn't it true that you met for the first time in July or August of 2002, just before her 14th birthday?
Same objections.
You know, your firm has been accused by the U.S. Attorney of perpetrating one of the largest. The U.S. Attorney's described it as that I may not risk losing their representation.
Isn't it true that Tatum Miller, as a 13 or 14-year-old girl, was taken to your house by another underage minor female, that being Yamo?
Form. Tissue, please. Napkin, sorry. It's like an exhibit. I would like to answer that question, like all the other questions. The U.S.
Form.
Therefore, that's what I will do.
You know who is, right? She had a lawsuit against you previously?
Form.
Again, the last name? Could you spell it for me?
Well, the pseudonym that she used in her lawsuit against you alleging similar facts to those alleged in LM versus Jeffrey Epstein was CMA versus Jeffrey Epstein.
And now the question?
You know who she is, correct?
Form.
I'd like to answer that question here, Mr. If I don't,
There for a while thinking hard about.
therefore, I must assert those rights.
When I asked you about you sat there for a while thinking hard about whether or not you knew them. Do you remember either?
I'm going to move to strike counsel's statement because, counsel, I don't understand the question on the table.
Is, or do you really have no idea who that is?
Form.
Do you remember Tatum?
Are you going to ask one question? Which question would you like answered first?
Do you remember?
I'd like to answer that question. I'd like to answer that question today. However, my attorney, how much I'd like.
Isn't it true that she was just about to begin her 9th grade year in high school?
Same objections. Form.
I believe her testimony in front of the FBI in a sworn deposition says something else, but I don't recall exactly what. I don't have any recollection.
Of
Form.
You asked the question of when I met her, I think. If I met her.
Okay, so you have no recollection as to when you met her.
I don't have any recollection if I ever met her. I just told you, I did read her FBI statement, so I know what she has said. And that's not what you've just represented to me.
So your only memory of Tatum, strike that, your only knowledge of any interaction you may have had with is derived from an FBI statement that she gave. Is that true?
I believe what you just represented, she said, was not what she had sworn to.
No, I'm not asking what she said. I'm asking, do you
I think you just
independently remember if she was entering into her 9th grade year in high school when you met her? Independent of anything you read.
Right. We'll just move to strike the diatribe between. I'm confused as to what question's on the table now.
Okay. Independent of anything you've ever read.
Okay.
Do you remember meeting just before she entered into her 9th grade year in high school?
I'd like to answer that question. Her sworn statements to the FBI contradict what you've just said. I have to invoke my 6th Amendment, 5th Amendment, and 14th Amendment rights.
Ever met her? So is that your testimony that you don't know if you've ever met Tatum Miller?
My testimony is very clear. I must assert the rights that my attorneys have asked me to assert today, though her testimony under oath to the FBI is not what you represented it to be to me and the ladies and gentlemen, the jury who are watching us, hopefully.
Form.
Okay. And we'll get into that.
Okay.
When you first came into the room today, didn't you look at me and say, I like the statement that you made to me?
Form. Move to strike.
I don't believe I said that.
What is it that you believe you did say, referencing when you sat down in that seat prior to the cameras rolling?
Form. Counsel, I was here during that whole time and I don't recall any such statement.
You went in the room.
I don't remember. I don't know. Sorry.
So is your testimony right now that you did not say to me, I like
That's
Objection.
That's
Relevance.
correct.
do you like Tatum?
form, predicate, and relevant.
I'd like to answer all your questions here as I've tried to.
You knew she was a economically disadvantaged girl that needed money?
Objection. Speculation. Assumes facts not in evidence. And it's argumentative as worded.
I'd like to answer all your questions here today. The U.S. So accordingly, I must assert those rights as guaranteed by the 6th, 5th, and 14th Amendment.
And when she was a 14-year-old girl, she was taken into your bedroom and you ordered her to take her clothes off. Is that correct?
Objection. Vague. Confusing. As to her, I'm not quite sure who you're...
Okay. When was a 14-year-old girl, she was taken up to your bedroom and you ordered her to take her clothes off. Isn't that true?
Objection. Speculation. And assumes facts not in evidence. Lacks predicate.
Though, once again, what you've just represented to me is in total contradiction to the FBI sworn statement that I read of Tatum Miller, I must unfortunately respond by asserting the rights demanded by my attorneys today, which is my 6th Amendment, 5th Amendment, and 14th Amendment right given by the U.S. Constitution. Though her testimony is exactly does not purport in any way to what you've just said.
And when was 14 years old, you ordered she begin to give you a massage while she was naked and you were naked. Isn't that true?
Same objections.
Sorry, you'll have to repeat the question.
Well, Tatum, when was a 14-year-old girl,
Right. Yes.
you laughed and said, right. About what?
And I didn't hear the first part of your question, so now I understood it.
Okay. When was a 14-year-old girl, isn't it true that you received a massage from her while she was naked and you were naked?
Objection. Speculation. Assumes facts not in evidence. And predicate. Lacks predicate.
I understand that your firm, you've just described it, though she swore to the FBI that under oath, and though I'd like to answer your questions here today, my attorneys have advised me I may not. And
Excuse me?
restroom break?
All right, we're stopping again?
Going off the video record at 1:49 p.m.
Thank you.
We're back in the video record at 2:04 p.m.
Mr. Epstein, when was a 14-year-old girl, isn't it true that while you were naked on the massage table, you ordered to take off her clothes and provide you a massage?
I believe I've answered that question.
I don't know where we left off, that's why.
Form. Argumentative. Speculation. It's a compound and assumes facts not in evidence and has been asked and answered. But we did take a break, so you can...
Okay, so the current U.S. attorney has described your law firm as involved in fabricating dollars. He used words like counsel, assert my 6th Amendment.
14-year-old girl providing you a massage, you ordered her to pinch her nipples during that massage. Is that true?
Same objections. Argumentative. Speculation. Harassing. Assumes facts not in evidence and lacks predicate.
I asked her to pinch her nipples.
Pinch your nipples.
I believe her own sworn testimony contradicts that statement, however, and I'd like to answer all your questions here today.
You began to masturbate in front of her. Isn't that true?
Same objections.
Again, fortunately, I'd like to answer each one of your questions here today. My attorneys have counseled me that today, at least, I have to assert my Fifth Amendment, Sixth Amendment, and 14th Amendment, and the fact that your firm has been a criminal enterprise involved.
Is it true that while you were masturbating, you inserted your fingers into her 14-year-old vagina?
Objection. Argumentative speculation. It's harassing. It assumes facts not in evidence. And the question continues to lack predicate. And I also believe the question is asked and answered some time ago.
Though I'd like to answer each one of your questions, the fact that your firm
that while was a 14-year-old female, you...
Same objections incorporated.
Again, the question?
Isn't it true that during this sexual massage, while you were that you masturbated to the point of
argumentative speculation, it's compound,
the 14th Amendment rights of
when she was between the ages of 13 and 16? Approximately.
I will assert those rights.
Isn't it true that the ritual that I'm describing occurred with approximately 100 times when she was between the ages of 13 and 16?
Same objections with the additional objection of vague and confusing.
Since your firm has been involved in, according to the U.S. Attorney, in craft representation.
In addition to the sexual abuse directly against Tatum that I have just described, isn't it true that you also paid her money to bring you more than 50 other underage minor females for you to similarly abuse?
Same objections.
Excuse me. Though I believe in her own sworn testimony to the U.S. government, she contradicts your assertions. And I'm sure that maybe you'll have some explanation at trial. But ladies and gentlemen, the jury should know about your firm being accused by the U.S.
allegation, a firm known as in response to my question. So I'd like for you to tell the jury at this time, which allegation are you now saying is fraudulent or untrue that is being made by
form, confusing. Same objections.
You understand the question?
No.
Okay. You made reference to this in response to my questions about what you did sexually to.
Yes,
you
sir.
have responded with these fraud allegations against the firm of Rothstein, Rosenfeld, Adler, and I want you to tell the jury which allegations that is making against you are you disputing at this time or calling a fraud or calling untrue?
Confusing, compound, and if the court reporter would read back Mr. Epstein's response, I think you will see that the way you just phrased the question mischaracterizes his testimony. Because, well, I'm going to keep it there, unless you want me to go further. You want me to go further? Because
No, I want him to go further.
Okay. Mischaracterizes a witness's testimony.
His own statements contradict every one of your allegations that you've made to me today. It is a hypothetical. In her own words, and the potential reasons that concern me is the fact that the law firm that represented and two others have been accused by the U.S. Attorney of fraudulently producing cases against me and others to fleece investors in what he's described as one of the largest frauds in South Florida's history. So it concerns me. It's a factor in the way I'm thinking about answering. Sorry.
Each time that you paid her $200, is that correct?
Objection, argumentative, speculative, it's harassing, it assumes facts not in evidence, and with regard to this line of questioning, the court has already ruled that the demeanor in which you're presenting this question is improper and harassing. So if you would...
I'm very comfortable with the demeanor right now,
if you would,
Mr. Pike. These are just the facts of the lawsuit. The facts are outrageous, and I understand that, but they have to be asked.
Maybe the demeanor and tone of your question is laced in a manner that it's proper for the video, but the content of the question is the same exact harassing question that was deemed by the judge to be argumentative. I'm not saying that he's not going to answer your question, or that you don't know what his answer is going to be, but what I'm saying is, could you rephrase the question?
Okay, answer that question. I'll work on rephrasing it for you.
I'm sorry,
That's my point.
I forgot what the question was by now.
Isn't it true that each time that you interacted with, you paid her $200 each time?
I'd like to answer... Sorry?
Form, go ahead.
I'd like to answer each one of your questions here today. However, my attorneys have counseled me that today I have to assert my Fifth Amendment, Sixth Amendment, and 14th Amendment rights under the U.S. Constitution. And I'm cognizant of the fact that your firm has crafted these malicious lawsuits. It's been reported that the lawsuits are of a sexual nature in order to fleece investors.
And isn't it true that for each underage minor that brought to you for the purposes of you engaging in sexual activity, you paid her $200?
Objection, speculation, it's a compound question. And
so over the course of relatively, roughly 3 years, isn't it true that you touched or fondled in a sexual manner on more than 50 occasions?
objection, argumentative, calls for speculation. It's
رادیو مناهج، راه نوین دانایی. مناهج.ir